Ineffective justice system in the subcontinent in other developing countries. Taking cues from the performances and responsibility carried out by the court judges of India, Pakistan, Bangladesh and other developing countries, can this be said that the responsibilities given by the nations and the constitutions and the customs and conventions of humanity, are fully met and dispensed by these courts and their judges? And if so, how these are being done for the common man? The question raised where is as old as the institution of the judiciary itself. Does the black-robed figure on the high bench actually deliver what the parchment of the Constitution, the sermons of the mosque-temple-church, and the whispered hopes of the widow, the tenant, the bonded laborer and the rape survivor promise? In India, Pakistan, Bangladesh, Sri Lanka, Nepal, Tanzania, Kenya, Uganda, Indonesia, the Philippines, Bolivia, Guatemala, Peru, Egypt, Jordan, in short, in every society that is still climbing the steep escarpment of development, the same drama is enacted every morning at 10 o'clock when the courtmaster shouts, "Order." The scenery looks identical: colonial-era courthouses with cracked fans, clerks dipping rust-nibbed pens into inkpots, files tied with red tape that has itself become a metaphor for delay, and a queue of human beings stretching from the veranda to the street outside. Yet behind this shared facade the performance is uneven, and the answer to your question has to be broken into three different timescales: the constitutional text, the daily practice, and the slow, almost geologically slow, movement of public meaning. 1. The constitutional promise, a sky without pillars. The constitutions of India, 1950, Pakistan, 1973, with earlier interludes, Bangladesh, 1972, restored 1991, Sri Lanka, 1978, and Nepal, 2015, are not modest documents. Each announces itself with the trumpet blast of a social revolution: justice, social, economic and political, shall inform all institutions of national life. India, art. 38. The state shall eliminate all forms of exploitation. Bangladesh, art. 20. All citizens are equal before law and are entitled to equal protection of law. Pakistan, art. 25. These clauses are copied, almost word for word, from the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. They create what the Indian Supreme Court has called a sky without pillars, rights that hover above the state, not gifts that the state confers. The judge is declared to be the sentinel on the qui-vive, the only official who is required to be independent and impartial even when the executive, the legislature, the police and the market are not. Side by side with the text, however, runs a parallel inheritance, the customs and conventions of humanity, that you mention. These are not written anywhere, but they travel in the oral memory of people: the notion that a widow should not be turned out of her husband's house, that a sharecropper deserves half the crop, that a girl cannot be married against her will, that water in the village tank belongs to everyone. Customary law lives in the interstices of the formal system. It is invoked in the village shalish, mediation, in Bangladesh, the jirga in Pakistan, the Kap Panchayat in Haryana, the Diga system in Karamoja. The answer given in the great cases: Kesavananda Bharati, India, 1973, State vs. Dasso, Pakistan, 1958, Anwar Hossain Chowdhury, Bangladesh, 1989, Kulbhushan Jadhav, Pakistan, 2017, Shilpa Agarwal, Nepal, 2021, is that the constitution is the apex, but the judge must carry the smell of the soil while climbing the constitutional mountain. 2. The daily practice, a sky with leaking roofs. Yet every empirical study done in the last 20 years, by the World Bank, UNDP, DFID, ODI, the Asia Foundation, the International Commission of Jurists, arrives at the same blunt conclusion: the formal judiciary in South Asia and comparable developing countries is not delivering the constitutional goods to the common man in the quantity, speed, affordability, or dignity that the text assumes. The ODI synthesis of 16 developing countries, 2001, found that Pakistan scored the lowest of all on judicial arena, with respondents saying the system was corrupt to the core, and that there is no such thing as justice. Bangladesh was rated only marginally better. India hovered in the middle, praised for the intellectual caliber of the higher judiciary but criticized for enormous delays, cost and distance. Tanzanian respondents said bluntly, justice depends on finance, access is inversely proportional to the amount of money citizens have. The same report noted that in Mongolia, Russia, Bulgaria, and Indonesia, judges still relapse into the laws of the old bureaucratic system, and that in China, the party organization at different levels is often above the law. These are not colonial caricatures, they are the voices of court users themselves. Let us translate the abstractions into the life of one hypothetical but entirely representative woman, Rabea Begum, a 34-year-old sharecropper in Kushtia district, Bangladesh. Her husband disappeared after being picked up by the police in a case of stolen fertilizer. She believes he is in the morgue, the police say they never arrested him. She wants the court to order the police to register a murder case. Here is what she encounters. Geography: the nearest district judge court is 38 kilometers away, the bus fare is taka 120, a day's wage. Language: the magistrate speaks in Bangla but the FIR is in English, Rabea cannot read it. Cost: the lawyer asks for taka 5,000, to make the case run fast, the court fee is another taka 1,200. Delay: the first hearing is given for 3 months later, on that day the police do not bring the case diary, the case is adjourned for another 6 weeks. Corruption: the reader whispers that if taka 2,000 is paid, the file will be put on top of the stack. Alternate forum: the village Shalish offers to mediate if Rabea accepts taka 50,000 from the police. By the time the Supreme Court delivers its final blessing, one of the parties is usually dead and the property has been subdivided among grandchildren. The system is not denying justice deliberately, it is drowning in its own weight. 3. The counter-movement, public interest litigation, alternate dispute resolution, technology and the moral heroism of individual judges. Yet the picture is not uniformly charcoal. Beginning in the late 1970s, the higher judiciary in India invented, almost by accident, a procedural device that has now traveled to Pakistan, Bangladesh, Nepal, Uganda, Kenya, South Africa, Brazil and Colombia, public interest litigation, PIL. The device is simple but revolutionary, a postcard written by a prisoner, a newspaper report about starvation deaths, a laborer losing both hands in a brick kiln, can be treated as a petition and heard the same day. The court appoints commissioners, receives affidavits, orders night shelters, midday meals, clean water, the release of under-trials, the demolition of illegal factories, the cleaning of the Ganges, the protection of the Sundarbans. In Hussain-era Khatun, 1979, the Supreme Court released 40,000 under-trials. In Sheila Bars, 1986, it separated juvenile prisoners from adults. In Vishaka, 1997, it created a sexual harassment code for the entire country. In Parmanand Katara, 1989, it ordered hospitals to treat accident victims first and ask for money later. Pakistan's Supreme Court followed suit. In Darshan Masi, 1990, it abolished bonded labor. In Shela Zia, 1994, it protected women against environmental hazards. In Soamotu case on Karachi killings, 2011, it forced the federal government to pay compensation to victims' families. Bangladesh's High Court Division declared rivers to be legal persons in 2019, giving the Turag and Buriganga the same rights as a human being. These orders are not paper tigers, they have released prisoners, closed mines, built shelters, paid compensation, even changed the color of the sky above Delhi during the 2021 lockdown when the court threatened to imprison the head of the pollution board if diesel taxis entered the capital. The lower judiciary, too, has begun to experiment: evening courts, mobile courts on boats and bullock carts, plea bargaining for petty offenses, lock adalats, people's courts, that settle 3.5 million cases in a single day in India, village mediation boards in Bangladesh that resolve 80% of marital and land disputes without a lawyer, paralegal committees in Nepal that accompany Dalit women to the police station, e-courts in Pakistan that allow a woman in Gilgit to give evidence by video link so she does not have to travel 600 kilometers to Rawalpindi. Technology, unevenly, imperfectly, is shrinking the distance between the constitution and the citizen. During the COVID-19 pandemic, the Indian Supreme Court heard 1.2 million cases online. In Bangladesh, a laborer in Satkhira got bail through a WhatsApp hearing. In Nepal, the Supreme Court live-streamed a citizenship case so that every stateless child in the Tarai could watch. 4. The moral biography of the judge, the last, fragile safety pin. Ultimately, however, institutions are only as good as the women and men who animate them. The Bangladesh Supreme Court's 14-point Code of Conduct, 2000, reminds every judge that any act, whether in official. Similar codes exist in Pakistan, Sri Lanka, Nepal, Kenya, Tanzania. Yet the same ODI survey found that corruption was cited again as a serious problem undermining the autonomy of the judiciary, and that in Kyrgyzstan, Togo, Russia and China, authorities do not want courts to really be independent. The only antidote is the moral biography of the individual judge. When Justice K. Chandru of the Madras High Court retired in 2013, he had decided 96,000 cases in 6 years, had never taken a vacation, had refused government accommodation, had dismissed his own nephew's suit, and had ordered the Tamil Nadu government to give midday meals to children even during summer vacation. When Justice Syed Mahmood Ahmed of the Sindh High Court was transferred to a remote circuit bench, he traveled by public bus, carried his own files, and released 1,200 under trials in 1 month because the police had forgotten to produce them. When Justice Shamsuddin Chowdhury of Bangladesh sat in a makeshift court on the veranda of a district guest house, he heard a petition from a 12-year-old T-boy who had been beaten by a police constable. He summoned the superintendent of police the same evening and obtained an apology plus TK 10,000 in compensation. These stories are not systemic solutions, but they are the safety pins that keep the constitutional fabric from unraveling completely. 5. The verdict, a sky still under construction. So, can it be said that the responsibilities given by the nations, the constitutions, and the customs of humanity are fully met and dispensed by the courts of India, Pakistan, Bangladesh and comparable developing countries? The honest answer is, no, not fully, but also not negligibly. The constitutional sky has been erected, but its roof still leaks, the columns have been quarried, but they are not yet strong enough to carry the full weight of social justice. For the Rabea Begums of these lands, justice is still a lottery, but the number of tickets is slowly increasing, the bus fare is still high, but the mobile court is now coming to the village market, the lawyer still asks for a bribe, but the paralegal girl with a smartphone is sitting next to her under the banyan tree. The distance between the parchment promises and the dusty reality is being bridged, plank by plank, by a combination of heroic judges, inventive procedures, angry civil society petitions, donor-funded pilot projects, WhatsApp bail orders, river rights judgments, and, above all, by the stubborn refusal of ordinary people to stop believing that a piece of paper called the Constitution can actually speak. It speaks haltingly, sometimes stammeringly, occasionally in a voice that is muffled by money or muscle. But it does speak, and when it speaks in the voice of a Chandru, a Mahmood, a Shamsuddin, or in the collective voice of 5 judges on a constitution bench who order the state to give food, shelter, dignity and clean air to those who have never entered a courtroom, then the answer to your question becomes a cautious, humbled, but still glowing yes in the making.